So, what happens when a lawyer walks into a room where they are by law not allowed to be? Sounds like the start of a joke, right? But it's actually the center of a real administrative case that went all the way to the Supreme Court. And it all started because a lawyer attended a simple community hearing. You see, this isn't just about one person breaking a rule. This case actually peels back the layers on a really unique and important part of the Philippine justice system. So let's get into it. All right, here's our game plan. We'll start with the setting, this lawyer-free zone. Then we'll get into the actual incident, what I'm calling the unwanted appearance. After that, we'll look at what the law books actually say, follow the case to its verdict, and really dig into the why, the spirit of the law. And we'll wrap up with the big principle we need to remember from all this.
Okay, first stop, a lawyer-free zone. We need to understand the Kataranggang Pambarangay system. So this whole story doesn't kick off in some fancy wood-paneled courtroom. Nope. It starts in a place designed specifically for neighbors to sort things out on their own without all the legal jargon and complexity. So what exactly is this system? It's called the Katarungan Pamarangay. Think of it as community-based justice. It was set up way back under Presidential Decree 1508. And the main goal? To give people a less formal, way more accessible place to settle disputes. To keep smaller issues from clogging up the main court system. The whole idea is simple. Get the two parties to show up in person, face to face, in front of a community panel called the Lupon, and try to reach a friendly, amicable settlement. No lawyers, just people talking. That's the key. All right, now for the main event, an unwanted appearance. Let's dig into the facts of this case, Malecdan versus attorney Baldo. So this is where that whole system gets put to the test. The story starts with a pretty standard complaint for estafa. That's fraud. But believe it or not, the fraud case isn't the real story here. The real drama starts when a lawyer shows up to the barangay hearing.
So here's how it all went down. On August 14th, 2014, there's a hearing for a complaint filed by a guy named Celestino Malecdan against the Baldo spouses. And who shows up? Their lawyer, attorney Simpson T. Baldo. Well, Malecdan was not happy about that. Just 4 days later, on August 18th, he files a new complaint, this time against attorney Baldo himself, just for being there. And things moved pretty fast. By September 15th, the whole thing gets kicked over to the IBP, the Integrated Bar of the Philippines, for investigation. And this is where it gets interesting, because you have two completely different stories. It's a classic he said situation. On one hand, you have Malecdan, who says, I vehemently objected to the presence of attorney Baldo. He insisted. He's saying, no way, I didn't want him there. But then you have attorney Baldo's side. He claims he asked for permission and that the complainant, Malecdan, readily permitted and allowed him to be there. So, who do you believe?
And right there, that's the pivot. The whole case suddenly wasn't about the alleged estafa anymore. That just faded away. The real issue, the core question that this entire disciplinary action hinges on, was this. Is a lawyer's mere presence at one of these hearings where they might be forbidden a violation of the rules?
Okay, so this brings us to the law itself. Let's look at what's actually on the books. What does the law explicitly prohibit? This is the heart of the whole dispute. So, this is the million-dollar question, right? Can lawyers even participate in barangay conciliation proceedings? This is what the disciplinary committee and eventually the Supreme Court had to figure out. Is there wiggle room here, or is it a hard and fast rule? Well, the law is actually crystal clear. This is from Section 9 of Presidential Decree 1508, and I'll read it. In all proceedings provided for herein, the parties must appear in person without the assistance of counsel/representative. It doesn't get much more direct than that. The law even goes on to say that the only exception is for minors or people who are incompetent, and even then, the representative cannot be a lawyer. So yeah, the ban is about as explicit as it gets. So, with the law being so clear, what was the verdict? Let's trace the journey to a final judgment. It's interesting because the penalty actually bounced around a bit before they landed on a final decision. Okay, so here's how it played out. First, it went to the IBP commissioner, and their recommendation? Just a warning. They actually found the language of the law to be not that definite. But then it went up to the IBP Board of Governors. They completely disagreed, reversed that recommendation, and bumped it up to a formal reprimand. And finally, the case made it to the Supreme Court, which settled it once and for all. They upheld the board's decision. A reprimand it was. Now, this is maybe the most important part. We know what the rule is, but let's talk about the why. What's the spirit of the law here?
In legal terms, this is the ratio decidendi, the core reasoning behind the verdict. Why does this prohibition exist in the first place?
To explain their reasoning, the Supreme Court actually pointed to an older case, Ledesma v. Court of Appeals. And the logic is fascinating. The whole point of keeping lawyers out is to encourage, and I'm quoting here, a personal confrontation between the parties without the intervention of a counsel, to generate spontaneity and a favorable disposition to amicable settlement. Basically, when you put lawyers in the room, things can get technical and adversarial. The system is designed for two neighbors to just talk it out, human to human, and hopefully find some common ground.
And to make sure that spirit is protected, the court emphasized that the law's language is intentionally couched in mandatory language. That means this isn't just a friendly suggestion, it's a hard rule, a command. You must appear without a lawyer. It's written that way to make sure the system actually works as intended. So by violating that one specific law, Attorney Baldo actually broke some even more fundamental rules for lawyers. This falls under the Code of Professional Responsibility. Canon 1 is pretty basic. A lawyer has to uphold the Constitution and obey the laws. And Rule 1.01 says a lawyer shall not engage in unlawful conduct. By showing up where he wasn't supposed to, the court found he violated both of these core duties. All right, let's bring it all home. We're at our final section, a principle to uphold. Let's look at the final ruling and the big takeaway from this entire case.
So the final verdict from the Supreme Court was unambiguous. They found Attorney Baldo liable. It didn't matter what his intentions were, or even if he thought he had permission. His very presence was a violation of Canon 1 and Rule 1.01 of the Code of Professional Responsibility. Period.
And here's the final judgment, straight from the court documents. This is the disposition. Wherefore, the court finds Addie Simpson T. Baldo liable, and he is hereby reprimanded with a stern warning that a repetition would be dealt with more severely. So he gets a formal reprimand on his record, plus a very clear warning, don't do this again. So what's the big lesson here? The doctrine this case cements is this. Lawyers are absolutely strictly prohibited from appearing or participating in any capacity in Karanggang Pambarangay proceedings. It's not about whether they speak or not. Their mere presence violates the mandatory lawyer-free nature of the system, and in doing so, they violate their fundamental duty as a lawyer to obey the law.
And that leaves us with a really fascinating question to think about, doesn't it? In a world that's so full of complex laws and legal procedures, this case reminds us of a system built on the idea that sometimes, just sometimes, justice is better served by taking the lawyers out of the room. It makes you wonder, when is direct, face-to-face communication actually more powerful than professional legal representation?